people now.
It's showtime.
This ain't what you want, bitch, I'm a fucking phenomenon.
Yo, yo, yo. Chrissy Nevada. Good morning. I literally just woke up. Just now. Let's see what's going on here. Still nothing yet. Good morning, Christy. How are you today? Very nice. My first guest. It is so nice to see you today. How do I look? Is my hair okay? Tony, the camera's on top of Tony. So, that's what we're working with here. Yeah. We're doing this today. Let's see. Okay. 16 hours of broadcasting yesterday. And that was one of the best days of my life. So, yeah. Let's get this open. They finally warmed up here a little bit, you guys. I'm not deathly freezing. I'm still not opening the damn door, though. Maybe I need to open this part. There we go. Leslie and Betty. Good day to you. Hello. Very nice to see you today. I'm trying to open this to show you the beautiful sunshine out here. I don't know if you guys are snowed in or what still. It's nice to have you here. Nope, no work. I didn't really check. Let me check. That's a good idea, Leslie. Thank you. Nope, we're clear. I do believe. Twiz woke me up, more or less. I got up. I'm gonna make some coffee in a second, and we'll get this thing underway. I wanted to get over in Dinky's chat to tell him to boost the audio. I don't know if he can do that in StreamYard or not, though. It sounded much clearer here yesterday. I don't want him to have a good stream today, and I don't want him to get struck again. Also, I mean, they didn't shut him down. Apparently, his video was back up, but it got taken down for a while. So I don't know what that was all about. But we definitely don't want to see him get in trouble. So, Tyler Dreamer's back. Yeah, Twizzle sticks. Twiz biscuit. My mouth is so. I gotta make some coffee again here in a second. If you guys will. I just don't want to miss court starting. This is, gosh. I wish I could hear you guys' voices. I really would love to have that. And they have that through, I guess, Discord. We could do it. So I'm planning on doing that. I really am. Rockford's very adamant about that. How are you today, Mr. Twiz? It is good to see you, my brother. Everybody, welcome in. I guess everything's going to go according. I thought it was going to start later. So, I don't know. Maybe I guess the redacted portion is over. And we're going to get to it today. And I'm just going to leave this up. I was going to check in with Twiz, though. Dinky. Let's see what he's got going on. Dial-up dreamer, she is a Earthlink fan. Is the last Earthlink, like the last members only jacket. Let's see here. You guys like my? There's Willie. Okay.
Upstairs, right above her room, was Maddie's room. So I'm guessing like she should have heard everything that's going on above her head. It's just a fucking house.
Especially if she's hearing somebody crying in the bathroom all the way. Because I'm guessing the bathroom is farther away than.
It's probably at the top of the stairs. Do you know what I mean? Like as you go upstairs, it's probably right in front of you, and then there's a room either side. Like on her floor, there's obviously a bathroom.
But here's my problem.
Twiz, you're the keyboard warrior today. Good morning, Pete Fox. How are you?
If we take that story, say as truth, then that means that somebody murdered somebody, and then the other one was crying because it happened. It wasn't like boom, boom.
Yeah.
It broke my light last night after 16 hours of broadcasting my lightsaber.
Her story doesn't make any sense. This is the problem, and this is what I've said right.
I couldn't get it to work.
They needed a witness to make their timeline.
$3 out the window.
That's the only reason that. That's the only reason that her statement says what it says.
I'll leave him running.
Yeah, and then watching her back, and then her saying,
I really got to make coffee, or I'm gonna die.
The shoe print.
Hey, Kane.
So what?
Yeah. Well, so what means that.
I put love you guys in the chat.
So close
Tiki's
to the
like,
door,
okay.
I'm guessing, and there's only one of them. So it just doesn't fit, but they tried.
Twiz has like 6
what
computers.
Anne was trying to expose yesterday is
12
how
gauge.
they told
Oh
this
man! I'm gonna play the Mrs. Doubtfire song for you guys.
To get warrants and stuff.
Twiz is like got a circular array of computers, 18 keyboards. It's like
is what she's saying, so it doesn't need to be in there. But they're trying to sell it as
see you, Twiz.
Yes, this footprint ties in with the killer leaving the scene, taking
Tony's
this
here.
like direction.
He's my help.
Yeah.
Oh Lord.
That's why it's in.
I'm not
But Anne's
hungover.
saying, but look, it's not relevant. I mean,
Today's whiskey day, probably.
was apart from the blood DNA.
Did you have a stream last night? Did you do the
being in the
I
house?
shouldn't talk.
Somebody's blood DNA, unknown male blood DNA on the handrail is huge to me.
Oh yeah.
I mean that's blood DNA.
Is this on a laptop?
To me,
I can't get my. You know, Twiz, I think I got a short in my laptop.
Anyway. Dude, the blood
and you know what I
is
can't
huge,
find is those. You know, I call them mixer cables.
You know, they always said, "Oh, victim's DNA close to the body, close to the body."
But you know what I mean? Those 2-prong cables
and remember
that they have, and you plug it in your mixer, and the one I need has 3 prongs. It's not a IEC power cable. It's like that thin cord but it has 3. And I had 1,000,000 of them at the studio, and I guess I lost them. So I can't get my laptop to work. It sucks. Yeah, that is rough on the small screen. Well, you can always hook up a monitor externally, right? If you wanted to. Let's see what's going on over there. Okay, I'm going to keep it here just in case. I'm going to crank up the volume because they have a bunch of whispering ass mofos over there in Idaho. And I'm just going to quickly make a coffee and grab whatever Pop-Tart I have. I have a Pop-Tart left. I do. 1 Pop-Tart left. Let me make sure I got the audio on here. Yeah, let me double check it. And I don't want to blow anybody out of the water here. Wow, we got quite a crew with Shelly Ellie and today. All the faunest of the ladies of the streets of the tube. Let's see. There we go. I better put Dinky next to me. I just need Dinky next to me at all times. That's what it is. Alright,
Can she say, well, look, this footprint.
We got audio. That's excellent.
Dylan's story is completely all over the fucking.
If there's a little overlap with Dinky
she
talking,
saw a picture of him. They showed her a picture, and she said, "No, that's not the guy." I mean, what the fuck?
I can see.
So they go by her description.
and
say yes.
Put out something too about it.
So they go with her description in the PCA, right? And then they tie that to Brian by saying it matches his description, like of the driver's license they saw of him when he got stopped
But then she said
traffic violation.
But then she said that she didn't recognize him or something.
Yeah, and then they show her a picture of him, and she doesn't recognize him.
And that's documented.
Yeah.
Oh my fuck. Because remember,
So it's like-
remember I said
so the
something
police
about a
say,
lineup
well,
and
no,
everybody was
it's-
laughing at me. They were like, "Why would they do a lineup? Why would they do a lineup?" She had a picture of the fucking guy and she couldn't identify him, but she saw his eyebrows. She saw detailed enough of him to see. And anybody that would see Brian's protruding forehead would have picked. Like I told you before, bro. If I saw, remember I said that like 10 times. If I saw
Also-
Brian's eyebrows and hold on, dude, give me a second, please.
She must have seen his eyebrows after the fact.
But it's not even
And
his
before,
eyebrows,
what I'm
it's
saying to you is-
protruding fucking forehead.
Yeah, but what I'm saying is the description in the PCA that she gave of the eyebrows, right?
Yeah.
They've then later on showed her a picture of Brian with eyebrows.
I
And she's-
understand,
and she's
but
still
I
saying,
always
well, no,
thought she
that's
was
not the guy.
mistaken. But I always gave her, I kind of always gave her the little benefit of the doubt that she was mistaken about the eyebrows and the protruding forehead, and she kind of took it as like
Possibly.
deep eye sockets and yada yada yada. But to hear that she couldn't even
Exactly.
identify him on a photo is just, now that solidifies it to me 100% that Brian is not the person she saw.
If she saw anyone.
If she was even there, because in my
She
opinion,
probably
I
was
think
there.
somebody took Murphy for a walk for a
Dude,
while.
She probably was there, but she was probably fucking out of it. And then she said to the cops, well, I think I might have heard this noise at this time, like, you know, somebody running up and down the stairs, and there was somebody crying in the bathroom. And then they've said, oh, you know, what about this and what about that? And they've just made it fit their timeline.
Yeah, we even sure the
Dylan
murder
didn't know.
happened that early in the morning and not at like 8, 9 in the morning. Like, why would Murphy just be chilling for that long?
No
Something-
fucking way. Was
something's
that?
off.
There's no way was that dog in
Something's
Kaylee's room with the door wide open.
Something's
And the
off.
doors were open. I've just listened to it again. The doors were open to the victims' rooms as well.
What?
So Maddie's room was open.
All of them?
Yep. Maddie's room was open, and so was Xana's room.
So what would possess Dylan to call Hunter over? It was my question last night, but nobody said anything.
No idea, dude. Because some people misheard it. Some people said it's only Kaylee's room that was open. Well, that's not true. I've listened to it twice now.
So then she has no reason to call over Hunter. The reason she called over
Oh,
Hunter is
tell me
because
this: how did the
Mother
dog
bitch.
just sit in Kaylee's room
The hell? Who's
with the door open and not wander around? Or
Here's
what?
the sickest part about it as a parent. I'm telling you right now, dude. If I, oh my motherfucker, she's not a, remember, she's not a child, dude.
No,
So
she's not a child.
you know,
She's-
this isn't something where I
she's
can I
less
would
of
hold
a
back.
child now.
But let me tell you something, dude.
Somebody call me?
If
Yes.
I had any inkling, if there was
Oh, you know what?
any
It's
inkling,
now I
if
realize
I
it's
saw
colder.
the medical
I was
report, stat,
curled
all
up in
that
this
shit,
damn
that if
blanket.
911 was called
I
right
am
away, that my
freezing
child
my
could have
butt
been
off now.
saved, and I hear that you were just dicking around
Look out
doing
my
this,
window.
this, and this, we got big
We got the,
problems, bro.
She wasn't dicking around. She was out of it. That's the problem. She was fucking out
Here
of
they're
it.
doing the.
Absolutely wasted.
Pipes.
And then when she woke up, she shit
Where are you?
herself probably because she was still wasted.
So, but nobody's that fucked up, out, wasted,
First
and
time
then
we've ever
wakes
seen
up.
anybody out my window.
Well,
Unless people are screaming their fucking heads off and being
And
murdered.
even if you did, all right, so
Crying in the
then-
bathroom is not waking you up, bro. I'm sorry. I've been
no,
the other night when I drank a half a
too much
bottle
for
of
me
wine,
right
I
now.
was fucking out. You couldn't wake me up with a train. With I swear to God, you couldn't wake me up with a train horn.
Oh, that's,
And
you know
you're
what,
telling
that-
me she
that's
wakes up by
coffee
somebody
right there.
upstairs crying in the bathroom?
Couldn't wake
Kiss
me up
my
with a
ass.
train horn.
Tell me this then. If she's so out of it, she doesn't remember if it's a dream or what she particularly
newest
heard or any
member.
of that stuff.
Well, maybe.
How the fuck does she know
We
what
got a
time it
few
is?
memberships.
And how does
So
she know what you saw?
precisely. How did she know so precisely?
How does she know the male?
what time
How
it was?
does she know a height? How does she know any of that shit?
Exactly.
Fuck her.
Exactly. That whole thing is like, yeah.
You guys,
So disgusting, man.
everything is
Yeah.
thrown
She
out
should have
the
been in
window.
jail.
I mean, I know.
It's a whole new world.
Like, I was
There's my battery
like,
life.
listening to
Well,
Annie, and Annie
fine.
was suggesting that maybe Murphy
I am
was in
so
the car.
sorry. I
But
thought you
Yeah,
said
I don't
something.
think
That's
that.
it.
I don't think for a minute Katie would have shut the dog in the car. All night. It was fucking freezing.
I appreciate the eagerness.
The,
Like dog owners
cover.
don't. You know what
All
I
right,
mean?
are we
Like no matter how much my dog pisses me off, I'm gonna shut
This
the
is,
car. Right?
continued
Especially
hearing
when
drop
states
here.
the
Kohberger,
Disgusting.
And she said, like, the dog was found in the room with the door open. How?
Yes, welcome.
Why
to
didn't the dog move?
Very nice
Like, why
to
didn't
see
it
you.
go
my
into
friend-
Maddie's
best friend
room
growing
and,
up,
like, jump
yeah.
on them? Oh, here we go. Right.
Was the first
Shut up.
Jennings.
I'll make
All right,
it.
yeah, I'm gonna drop down and watch it with my
Her name was Dana.
I'll be back.
Dana
Discuss
McCarthy.
the motions to
Here we go,
suppress
guys.
and any evidence related thereto. as
I
well
got
as,
this. I got this.
claims
Look.
to argue
Oh, I am
against.
so
not
sorry.
blowing.
I
With
thought you
that,
said
I understand the parties are prepared to proceed. The defense, I appreciate witnesses to call this morning.
We do, Your Honor.
All
We
right.
have two.
All right, who's your first witness?
Corporal Brett Payne.
All right, let's get going with that then. If
No
Corporal Payne would
way.
Step forward. You were sworn yesterday, as I recall, but we'll go ahead and do it again just for formality's sake.
Shaggy.
Good morning.
Morning, ma'am.
Could you please state your name and spell your last for the record?
Brett Payne, last is spelled Payne.
And what's your title?
I'm the detective corporal for Moscow Police Department.
Can you tell the court, I know you testified yesterday, but it was a different hearing, and so just to lay a little bit of foundation, can you tell the court your background in law enforcement?
So I've been with Moscow Police Department for almost 7 years now. Prior to that, I was in the active duty military for 6. 3 of those were as a commissioned officer in the Military Police Corps.
What is your role in this case?
I was assigned lead detective in this particular investigation.
And so, as lead detective, can you explain from your perspective what that has meant that you have done?
Certainly. So it was my responsibility to basically view this investigation from a 30,000-foot view, if you will. Direct the teams that were assigned to various tasks, and then take in all that information, synthesize it, put it back out to our group, and then eventually consolidate it into an affidavit.
And in terms of that affidavit, yesterday there was some discussion and testimony about that and how it was created. Would you explain that?
Absolutely. So the information was brought to us via various teams and specialists in their particular areas. For instance, most of the cell phone stuff was covered by Special Agent Balance from the FBI. All that information was brought to the team, relayed back out at least twice a day, and then as that information was essentially synthesized, it was put into a running document, a living document that is now known as Exhibit A.
So when it was characterized yesterday as a group effort, do you agree with that characterization of it?
Yes, ma'am.
And do you know approximately how many warrants you worked on in this case?
I don't, ma'am. Several. I don't know the exact number.
Right. I'm going to walk you through several segments of different warrants, and some of this may seem choppy, but I'm going to try to do you and then Detective Mowry at once instead of bringing you back and forth. Does that make sense?
Yes, ma'am. Sounds good.
All right. And Judge, I have paper exhibits for you and for the witness. And so I'll go as fast as I can, but I want you to be able to look at what he's looking at. So we're going to begin with the first AT&T warrant. Prior to this case, had you ever secured an AT&T warrant?
No, ma'am. I don't believe I had.
And so, given that, who did you rely on in creating the warrant for
Largely
AT&T?
Special Agent Balance. Obviously, he's the CAS expert, so I relied heavily on his input.
At the time that AT&T warrant 1 was secured, were you co-located with Special Agent Balance?
I believe so, yes.
Can you, well, in terms of being more specific, it was December 23rd. Were you two co-located at that time?
I believe so, yes.
And I know co-located has been talked about in court a couple of times, but can you just explain what it means for you two to be co-located since he's from DC?
Certainly. Yeah, he was in the same building as I was, just mere feet away from the command post.
Okay, so when you say mere feet away, were you guys in like a cubicle setting, or were you in offices with doors? What was this setting in terms of proximity to each other a few feet away?
Yeah, separate offices with doors, but in the same second floor of the Moscow Police Department.
Are you aware of Special Agent Balance in his work in doing AT&T records, having any access to AT&T records without a warrant?
I am not aware of that, no.
Are you aware of him having any ability to review AT&T records through any portal without a warrant?
Not to my knowledge, no.
I'm going to begin with what is known as State's Exhibit 1 attached to their objection to the motion to suppress AT&T warrant. And Judge, for today's purposes, what I'm doing is relying on the labels that are in the record as opposed to giving them new stickers.
This has been marked previously as States S1, or is that 8-1? I can't.
I think it's SS for State 1.
All right, States S1 affidavit for search warrant.
And now I've got to get...
Objection to the admission of that for today's hearing.
You know, Judge, I should have started out by saying that the same stipulation regarding the admission of all exhibits applies today.
We do need the formality of moving for the admission, however. So that's why
I can do that. Do you want me to do that per exhibit?
Well, it makes, as you're talking about them, it probably makes sense.
Okay, I've got to get myself S1. Okay, Detective Payne, can you look at page 5?
Yes, ma'am.
On page 5, can you read what it says in the at the very end of the page in the sentence above wherefore that begins with the paragraph? It begins in support. Can you read that paragraph?
Certainly. In support of the assertion as to the existence of probable cause, the following facts are offered based upon personal knowledge of affiant. See attached statement of Brett Payne, which is marked Exhibit A and incorporated as though fully set forth herein.
And is that S1 the affidavit in support of the search warrant?
Yes, it is.
And that's the AT&T 1 search warrant that was the first one served on December 23rd, correct?
That's correct.
And that language that you put in there, Exhibit A, is incorporated as though fully set forth herein. Is that the language you just read?
Yes, ma'am.
All right, I'm now going to hand you State's Exhibit 2 to the AT&T first warrant. Can you review that first page, the first paragraph?
Admission of S2.
Pardon?
Are you seeking the admission of S2?
I am seeking the admission of S2. Just to be clear, Judge, all of these that I'm putting before him and the ones that are attached, we're seeking the admission of.
No objection to S2? All right, it's admitted.
Have you reviewed that, Detective Payne? Do you see that the language that I just referred to in the search warrant affidavit, do you see that same language in this warrant in where you incorporate the affidavit, incorporate Exhibit A into your, you see that language
Ma'am.
in S2? And is S2 the actual search warrant for AT&T?
Yes, ma'am, it is.
Can you turn to the last page on page 4? What time was the warrant served?
10:03 a.m.
Do you recall that the return on that warrant came in at 3:30 that day?
That would sound correct. I don't remember specifically.
Would it help if I showed you the AT&T Mobility Propriety front page to verify?
Yes, ma'am.
Judge, I'm not seeking the admission of this, just for purposes of him being able to be certain. Sorry.
The witness may be shown the document to refresh his recollection.
Yes, Your Honor.
And Judge, for the record, this has also been admitted already in Frank's D17, page 634. Detective, can you see on that that came in at, I think it's 15:30? It's,
15:31.
okay, thank you. I'm now handing you Defense Exhibit A to the reply to the AT&T suppression motion.
This doesn't have a sticker on it?
Pardon?
This does not appear to have a sticker on it.
No, it does not, but it is attached to the reply as Exhibit A, AT&T. And that reply is, okay. Can you see line 4 there? Oh, sorry, Judge.
Copy and put, let's just, do you have a number that we were going to call this?
I would call it Exhibit A to reply, because that's what it is in the record. You see at the bottom of the page where it says Exhibit A, AT&T?
So this is the return of the warrant of S2?
Yes.
All right, let's call it S2.2. Or 2.1, pardon me.
That's fine.
The fact that it's associated with that particular warrant. Allowed to touch stickers under the union contract, so why don't you give it to the bailiff?
Detective Payne, on page 2 of that Exhibit A, it's actually just the front page where it says Affidavit of Brett Payne. What does paragraph 4 say?
Paragraph 4 or line 4?
Line 2. Line 4.
It says the warrant was served on 12/23/2022 by email, fax, etc.
So do you know exactly what method was used?
I don't remember.
Okay. And it says warrant in that line, right?
Yes, ma'am.
Does it say anything about the affidavit in support of search warrant accompanying the warrant?
Oh, ma'am.
On the next page, the receipt and inventory of warrant, do you see that?
Yes, ma'am.
Can you look at description of property? What does that say?
It says 509-592-8458.
Can you explain how that's a description of property and what that means?
It just means essentially that there was the information retrieved as a result of that phone number being queried with AT&T.
And it indicates that that was produced how?
Entrance was obtained by email.
And when that was received, did you do anything to verify that the data was within the date ranges of November 12th to November 14th of 2022?
I don't remember. That information was provided to Special Agent Balance as soon as it was received.
Do you have, when you say that it was provided to Special Agent Balance, is that because you don't have the capacity, technical skills, I guess, to review that raw data and do something with it?
Yes, ma'am.
Was there anybody else that you relied on for that, other than Special Agent Balance?
Not that memory brings to mind.
Let's now turn to the AT&T2 pen trap and also known as pen trap and trace. Can you explain what a pen trap and trace is?
So, pen register, best of my knowledge, now granted, I am, as I've stated before, I'm not an expert in cell phone stuff, but to the best of my knowledge, a pen register tracks incoming and outgoing phone calls, text messages, so on and so forth. And then the trap and trace is the portion that essentially gives you location data, or the precision data, precision location data rather. So it's essentially incoming and outgoing calls, what messages are received, and then part of that was where that phone was located when it was doing it.
Was it required that you secure the AT&T first warrant to obtain the second warrant that included a pen trap and trace?
I don't believe it was required.
So when the data was received on at 3:30, you gave that data was given to Special Agent Balance?
Yes, ma'am.
Okay. And then what happened in between 3:30 and 4:53 when the second warrant was secured?
Are you talking technically speaking, or can I speak in generalities? Because that's all I really know.
Well, I want you to talk about what you know.
So the only thing I know is that that information was provided to Special Agent Balance. He utilized whatever tools he has at his disposal, and then it was decided upon to go after the second pen trap and trace.
When did you start drafting that second trap and trace?
I don't remember.
So on that day, you did one in the morning that was secured at 10:03,
Yes, ma'am.
and then the second one was secured at 4:53 p.m. And you don't have a recollection of when you were working on those?
I don't remember, no.
All right. I think you have State's Exhibit 2 in front of you.
Yes, ma'am.
Can you flip back to that one? Can you see on page 1, what does it say that the time of that warrant was obtained?
Talking about State's Exhibit 2. Oh, 10:03 is what it says. Is that what you're referring to?
No, I'm referring to the return, which should be in, I might be referring you to the wrong exhibit.
Point 1, I believe.
And that was at 4:53. The second warrant was obtained at 4:53. I might not have handed you pen trap.
I don't think I have that one.
Yeah, my understanding is, just so we're clear, because I'm getting a little confused, is that we have the affidavit for warrant, the warrant, and the return of the warrant all related to the first warrant to AT&T. And we haven't got the pin, trap, and trace warrant presented yet, I don't think.
Right, I've got it here. And Judge, for clarification purposes too, today as we're going through testimony, my plan was not to go through every single warrant that we're arguing about and get it in front of the court. I'm really trying to take kind of a scalpel approach on the issues that we want to point out to the court. So it does really feel like I'm jumping around, and I realize that. I hope to bring it all together in the end.
The only caveat being what I've told you before is where you have is a broad array of documentation that you've presented. The court will not scour the record to find support for your motions that's not pointed out to the court specifically. And that's well established with case law from the Idaho Supreme Court.
And Judge, that's why I am trying to grab the pieces and parts that I want you to be able to identify, and that's why I'm putting the paper in front of you. So I'm hearing you when you've asked us to do that. All right, I'm handing you State's Exhibit 1. And this is to the second AT&T warrant, also known as Pin, Trap, and Trace.
This one is also listed as S1 on the sticker. So that's going to cause some problem, I suppose.
It's S1 attached to a different motion to suppress.
Well, hopefully we can figure it out when we're looking at the entire record, but
Yeah. And what I think, Judge, when you are going back and working with your clerk.
my concern, frankly, I know what all the documents are and what they relate to.
Yeah.
My concern is a reviewing court's ability to understand what you're talking about in court today and trace it to a stack of documents. That's my concern for this, so.
And I understand that. And so in preparation for today, I mean, I really did think, do I need to go through and label all of these? And I thought that would create more confusion in the record because these are all attached to specific motions with these labels.
This is marked S1, titled Affidavit for Search Warrant and Application for an Order for PIN Register or a Trap and Trace Device.
Yes.
So here on the record what we're looking at.
So Detective Payne, is that the warrant that affidavit in support of the search warrant that you drafted for that second AT&T warrant?
Yes, ma'am.
On page 11, at the bottom of the page, can you read that last sentence under probable cause?
Certainly. In support of the assertion as to the existence of probable cause, the following facts are offered based upon personal knowledge of the affiant. See attached statement of Brett Payne, which is marked Exhibit A and incorporated as though fully set forth herein.
All right, I am now handing you S2, which is the search warrant and order authorizing installation and/or use of PIN register trap and trace device and non-disclosure order pursuant to Idaho Code 18-6772. Can you please turn to page 7? Can you see what time that was obtained?
4:53 p.m.
I'm now handing you what is titled Return of Search Warrant, Exhibit A to Trap and Trace.
Does that have a sticker on it?
Pardon?
Does that have a sticker on it?
No, it does not.
It's 2.2.
What'd you call that, Judge?
S-2.2.
S-2.2.
Further delineated by the title, which is related to the pen, trap, and trace.
On page, can you look at page 2? You see the top, who does it say it's the affidavit of?
Corporal Brett Payne.
Are you looking at Exhibit A, page 2?
Oh, correction, I see what you mean. Affidavit of Lawrence Mowry is what it says at the top.
Right, and then, but is that actually your
It is, yes, ma'am.
affidavit? Okay, so that was a mistake.
Yes, ma'am.
On page 2, the top of it says affidavit of Lawrence Mowry.
Oh, gotcha.
It's the affidavit of Corporal Payne.
A heading problem there.
I'm now handing you Exhibit C to the reply to Trap and Trace. It does not have a sticker, and it says AT&T Mobility Carrier Request Form.
This again relates to the trap and trace warrant.
It does.
Let's mark that S2.3. In the next day or so, if you would provide a formal identification list, if you will, of the exhibits that you'd stipulated to admission to yesterday, as I don't think we went through those individually, just so that there's a record of that.
We can do that. Might take us a couple days, but we can do that. Can you look at, are you looking at that Exhibit C, Detective? Was cell site location data requested for this warrant on this page?
Yes, ma'am.
And was a timing advance report requested on this page? I'll refer you to the last paragraph where it says remark special instructions.
Yes, ma'am.
And do you see any reference in this document indicating that the affidavit in support of search warrant was included with the warrant?
No, ma'am.
Okay, the next warrant I want to talk about is Apple. Prior to this case, had you ever prepared an Apple warrant?
I don't remember.
What was your training related to Apple warrants in December of 2022?
I had no official training at that time.
I'm handing you what's been marked as Defendant's Exhibit A. It does have a sticker, and it's to the Apple motion. Can you state what that document is?
Appears to be a preservation request.
And who is it sent to?
Apple Corporate Legal Counsel,
And what's its date? What is the date on it
December 21st.
of 2022?
Correct.
And that letter was not sent by you, right?
No, I do not remember sending this, no.
Well, can you look at
That's not me.
Yeah, the top of it is Department of Justice, and the back, page 2 is Special Agent in Charge Dennis Rice.
Correct.
How was the DeSales email account known at that date?
I don't remember.
How did you become aware of an Apple product in this case?
Memory serves, when the search warrant in Pennsylvania was executed, there was an iPad that was located in one of the shared living spaces in the home. And there's a receipt in his vehicle, in Mr. Kohberger's vehicle, that was found for an iPad as well.
And during the home search, was the iPad seized?
It was not.
Why not?
It was in a shared living space.
Do you remember what day that the Apple account was created?
I don't remember. No, ma'am.
Does 2016 sound familiar with the research?
That sounds vaguely familiar, yep.
And you mentioned the receipt that was found in his car. Do you recall the date that indicated that an Apple product was purchased?
I do not remember.
Right, I will show you State's Exhibit 1. To the affidavit for search warrant. And I believe it's tabbed, the receipt.
This is State's Exhibit S1, affidavit for search warrant to Apple Inc.
Is 2018 the date?
Yes, ma'am.
Where did you get the form to prepare the Apple warrant?
Form? Be more specific?
Correct, the search, so you're looking at the search warrant affidavit, and inside of that affidavit is a long list of items that you request.
Yes, ma'am.
Where did you get that information to be able to include that?
That was all provided to me from the experts in that particular field.
I'm just getting S1 in front of myself for a minute here, Judge, so I don't, or I'm gonna have to give him a different exhibit.
Just so I'm clear, are those when you said the long list, are you referring to paragraph B on page 2?
On page 2, beginning on page 2,
Is that what you're referring to?
I'm referring to everything A through I.
I'm sorry, was there a question pending? I kind of threw us down a side alley there, so I apologize if there was a question pending that I threw you off from.
No, that's fine, I'm looking for the page here. Do you recall that in your affidavit, there's reference that iOS devices can use an iCloud account to back up the iOS device?
Yes, ma'am. That sounds familiar.
And what's your understanding when an iOS device uses an iCloud to back it up?
Similar to Google and many other of these digital operating systems, essentially they back it up to a cloud account. That information is stored not on your device only, but also in a cloud storage area. And that's my understanding of it.
And so in an Apple phone, that ends up as creating a duplication of what's on the phone?
Essentially, yes.
And do you recall that in the affidavit, you made reference to the fact that Apple users get 5 gigabytes typically of storage and then can purchase more?
Yes, ma'am.
Exhibit D. I'm handing you what's been marked as Exhibit D it's Defendant's Exhibit D to the Apple memorandum in support of suppression, and it is it does have a sticker.
All right, it's marked Defendant's Exhibit D, date 11/14/24, entitled Affidavit for Search Warrant, directed to Apple Inc.
Can you please turn to page 27?
The actual warrant itself that you're...
Yes.
Yes, ma'am.
Well, it's I don't want to answer that as a yes before I look and make sure what this exhibit is.
Want to make sure, because my page numbers run out at 25.
It's Exhibit A, and it's to the Apple warrant. It says, so Exhibit D, Apple, at the bottom, that page says page 27, but above that, it says page 23.
Yep, I'm there.
Okay. At the top, it says, on January 27th, Apple Inc.'s Privacy and Law Enforcement Compliance Office responded
Right,
with the
Counsel.
requested records.
I'm not there, so can you?
Oh, I'm
give me some
sorry.
direction? Are we looking at state
Exhibit D,
D?
yeah, page 27 of my marking bait. So it says Exhibit D, Apple page 27.
On January 27, 2023.
Yes.
All right, go
yes. On January 27, 2023, Apple Inc.'s Privacy and Law Enforcement Compliance Office responded with the requested records. Can you explain what Apple responded to?
I don't remember what all they responded to. They responded to the search warrant and all those listed items that were in the warrant itself.
And the warrant, the date on this, if you will turn to, let's see. Turn to page 34 of the exhibit. Do you see the date of the warrant?
1st of August.
So I understand that you just said you don't know or you don't remember, but in this context, in your search warrant affidavit, you make reference to something being produced on January 27th to process to get a warrant on August 1st. Do you know what the process was that Apple responded to or what they produced?
I do not remember. No, ma'am.
I am handing you Defendant's Exhibit B to the Apple Defendant's Memorandum in Support. It does have a sticker on it.
All right, the exhibit, just for the record, is Defendant's Exhibit B, date 11/14/24 on the sticker, and the title is Certification of Apple Inc. Custodian of Records.
Detective Payne, on this, there's a certification, this document is a certification of Apple Inc. Custodian of Records. Do you see that?
Yes, ma'am.
And it indicates that records are certified and being produced from legal process served on to Apple on January 12th, 2023.
Yes, ma'am.
Do you see that? What was served as legal process on Apple on January 12th, 2023?
I don't remember.
You know what the legal process would be?
I don't remember what that would have been.
Going back to Exhibit D. Do you have that one in front of you still?
Yes, ma'am.
Can you turn to page 35 of that?
Yep.
On line 4, what does it say?
Warrant was served by Corporal Payne on August 1st, 2023 via law enforcement at apple.com.
And so that would have been the Apple warrant, right?
Correct.
And you served it, right?
I believe so.
Well, when you say you believe so, would you have executed an affidavit if you hadn't?
No, ma'am, I just wanted to make sure on the warrant return itself that it wasn't served by one of the digital forensics folks.
This affidavit is your affidavit, and line 4, it says you served it, right?
Yes, ma'am.
Did you serve that with a copy of the search warrant affidavit?
No, ma'am.
Was it your practice in serving all of these warrants that where you actually did service, that you would serve the warrant only?
Yes, ma'am.
And then on Exhibit D, page 37,
Okay.
at the bottom where it says description of property, can you explain what the return was for that Apple warrant?
All account information associated data for the following Apple identifiers, and it goes through DSID, Apple ID, B. Kohberger at spartan.northampton.edu, another DSID, and Apple ID, Wi-Fi Army owns at yahoo.com.
Did you open up the Apple data and examine that?
I don't remember if I looked at what the return, like all the files that were attached were.
In terms of evaluating that Apple data, as the lead investigator, who have you put in charge of evaluating Apple data?
I relied on the specialists in those fields, which would be Detective Mowry and then S.A. Balance. Those are the folks who knew far more about it than me.
And do you know, as we sit here today, whose job it is to evaluate the Apple data for this case?
I don't know, ma'am. Not right now.
Okay, the next warrant we will talk about is Google. I'm handing you what's being marked as Defendants D to the Google memorandum in support of suppression.
Right, so that I'm clear and the record's clear, this is Defendant's Exhibit Number D with the date on the sticker of 11/14/24, which refers to the sticker date, I believe, not necessarily the document date. And then it's entitled Return of Search Warrant, the warrant being with respect to the application of search warrant for Google LLC. That as the other documents that were proffered are admitted.
Did you prepare the Google warrant returns Exhibit D?
Yes, ma'am.
On page 2 of that exhibit, does your affidavit say Detective Mowry served the warrant through a portal?
Yes, ma'am.
How did you know that?
Told me that.
When did you get the return? When you got the return, did you review the data?
I did not, ma'am.
Did you take any steps to see if the return conformed to the warrant?
I did not look at the technical data it contained within. I believe it was a zip file that was downloaded from Google, if memory serves me correctly. I downloaded it and made sure that that was there.
And do you recall that there were actually 3 Google warrants? Does that sound familiar? I'm going to hand you now Defendant's Exhibit E. The Defendant's Exhibit E to Google memorandum in support of motion to suppress.
All right, defendant's exhibit number E, again with the date on the sticker, 11/14/24. This is a receipt and inventory of warrant to Google.
On this document, under the description of property, can you state what Google account you put in as received?
Zip files for all digital records for the Google accounts of brianchristopher@gmail.com and username spelled a bit different at gmail.com.
Did you know that the email in the warrant is actually brianchristopher1994@gmail.com?
Oh, that sounds familiar. Yes, ma'am.
Okay. So on that description, is that a mistake?
Yes, ma'am.
And did you do anything to, I asked you this, but you didn't do anything to verify that the data that you received from Google fit what was requested in the warrant?
No, ma'am. Not to my recollection.
Right. That's it for Google. You were in Pennsylvania for Mr. Kohberger's arrest, correct?
Yes, ma'am.
And you watched the preparation for service of the arrest warrant?
How do you mean?
Well, maybe I should ask this more open-ended. Tell us about your arrival in Pennsylvania in time-wise to his arrest, time frame of his arrest.
I believe we arrived there, if memory serves, about 7 p.m. on the 29th. And I think I get my dates right here. We observed final preparations for the SRT operation that was going to take place. And then we being myself and Detective Gilbertson from ISP, drove to a separate Pennsylvania State Police barracks to await the arrival of Mr. Kohberger.
When you were observing preparations, what were you observing?
I believe we observed their final tactical brief for SRT. And that was about it.
Can you explain what that was, what the preparations were that they were making when they were doing that tactical brief?
I can give you a general overview, as best I got. So they had their entire SRT that was going to be conducting the operation present.
For the record, SRT is?
A special response team, usually what it stands for, Your Honor. So they were doing their final preparations, going over their approach, team member assignments, so on and so forth. This was all done via basically a briefing in front of everybody.
And do you recall that the preparations included that in preparation they were going to knock and announce in execution
I believe that was brought up, yes, ma'am.
of the warrant? Okay. And while you were there, did you go into and have were you given a tour, or did you drive into the gated community of Mr. Kohberger and see where he was living?
No, ma'am.
You never went in or around his home?
No, ma'am.
When the execution of the arrest was happening, did you have the ability to listen in any way?
The only ability that we had at the time was a very choppy drone feed. We were driving at the time it happened, and that was the only communication we had.
And so how was that choppy drone feed being communicated to you?
Via cell phone.
So can you explain that? Like, who's the person communicating with you? about the drone. I just don't understand.
So essentially, it's a drone operator with their SRT. I don't remember how it was conveyed, a link of some sort. They dropped a drone, it took off. I got the link so we could essentially just watch a live feed of what the drone was seeing, and that was it.
Do you know if that live feed was recorded?
I do not know, ma'am.
Did you record the while that was happening? Did you create a recording?
No, ma'am.
What is a Bearcat?
Bearcat's an armored vehicle used in SWAT operations.
And do you know what role the Bearcat? Describe that vehicle again.
So they're usually built on, I think it's like a Ford F-250 chassis. So it's a pickup cab essentially, but it's got a large box compartment in the back, for lack of a better term. Usually has portholes on the sides. It's highly up-armored to protect the occupants, being SWAT operators. And they usually use them as an approach vehicle, so they have a covered location to deploy from.
Is it a like a retrofitted military piece of machinery?
No, ma'am.
It's specifically a law enforcement piece of machinery?
Yes, ma'am.
And it sounds like it's really big.
It depends on what you're comparing it to. I'd say it's no bigger than, if you were to have a pickup camper on the back of an F-250, something like that.
And what's your understanding of where that Bearcat was parked for the arrest?
I believe the Bearcat, if memory serves, drove up the driveway and just parked in front of the house.
I'm handing you what's been marked as State's Exhibit 5 to the motion to suppress, and it was attached to 119 Lambsden.
All right, this is marked with an exhibit sticker S5. Title of the document is Pennsylvania State Police. Heading with essentially a letter directed to Detective Payne.
Detective Payne, can you explain what that letter is?
That's a justification for reasoning for amending the original plan for knock and announce to a hasty knock and announce and quicker entry into the Kohberger home.
When did you receive that?
I believe this was recently. I don't remember what date.
When you say recently, was it received in response to prepare for today's suppression hearing?
I believe so.
Do you know why Mr. Lang didn't date the letter?
I have to ask him, ma'am.
And so in that correspondence, he explains that the knock and announce was shortened to announcing from the Bearcat with immediate forced entry.
Yes, ma'am.
Were you present when Detective Gilbert Mirandized Mr. Kohberger at the station?
Detective Gilbertson?
Gilbertson, sorry, yes.
Yes, ma'am.
And that took place after Mr. Kohberger was first seized in his home, right?
Correct.
That also took place after he was transported in the back of a police car to the station, right?
Correct.
You noted in your report that Detective Gilbertson had a recorder in his pocket at the time of the interview.
I believe so.
Were there any recordings that took place at the Kohberger home when entry was made into the house?
I do not know.
Where was Mr. Kohberger's car parked at the time of his arrest?
It was in the garage.
Was it later seized pursuant to a search warrant from that garage?
Yes, ma'am.
And when you said that the iPad receipt was found in the car, is that the car that you're referring to?
Yes, ma'am.
That is all the questions that I have for you. Thank you.
Cross-examination.
We have just a moment, Your Honor.
The state doesn't have any clarifications for this witness.
All right, thank you, Detective. You can step down. Actually, if you don't mind, I actually have a question.
Of course.
You testified that you didn't send the affidavits in support of search warrants with the warrants themselves to Google, Apple, et cetera. And the persons that processed the evidence received, would they have knowledge of and access to the affidavit?
Absolutely, Your Honor.
Questions and follow-up to that?
I do. How would people that are getting an email through a portal, Apple, Google, AT&T, how would they have access to the affidavit?
My question was the people that received the evidence, not the people who sent it. So in other words, the police and team that reviewed the evidence, did they have access to it? Not, that wasn't my question.
Okay, I didn't hear you. You do
Just
have.
to clarify.
You do have a soft voice, and I am losing my hearing. But so then based on that, how would those folks get access to the affidavit in support of the search warrant when they're reviewing materials?
Just so I'm understanding you, those folks, meaning the people who work for these companies, is that who you're referring to?
No, I think that's not what the judge was
Right, I
asking.
understand.
He was asking that once that evidence is returned and you log it, his question was, do they have access to the affidavit in support of search warrant?
Right.
And your answer to him was yes, absolutely.
Yeah.
How?
There were paper copies of it. It was no secret. It was shared freely amongst the investigative team.
Okay, but not each person reviewing, various people are reviewing these, the electronic data for the some 67 devices and third-party warrant returns, right?
Yes, ma'am.
And in terms of my question earlier, which was who, I was asking about Apple, who's reviewing that data? Your answer was, I don't know, right?
Yes, ma'am.
So if you don't know who's reviewing something, how would you know that they have access to a search warrant affidavit?
Well, that's the beauty of having a collaborative team effort. If you share the information freely, it's not independent upon myself to provide that to them. Everybody has that information to reference.
So is in the database that you're creating with this collective, I'll stop this, break this down. My understanding is that the collective document is Exhibit A, correct?
Correct.
And then when you attach Exhibit A to a warrant with Exhibit A to a affidavit in support of a search warrant, you also add additional language depending on who that warrant is for, right?
Correct, yes, ma'am.
So there are over 100 different search warrant affidavits in this case. And it's your testimony that everybody who would have access to doing review of data has access to go in and look at what exact search warrant affidavit was executed?
I believe so, yes.
Okay. I have no further questions.
Follow up from the state on that. All right, thank you, Detective.
Judge, I think we don't need to step away, but I do need a break to organize my documents
Just watch you.
for the next witness, who will be Detective Mowry. All right, the defense calls Detective Mowry.
All right, and if Detective Mowry can come and be sworn. One of my staff took the opportunity to take a break. They'll be back in a second, so we'll just get them sworn in and we'll wait for them.
Do you solemnly swear affirm the testimony you're about to give now before the court is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
And I think it's fine if you just want to start with if you're going to ask him his background, you can do that.
Thank you.
Good morning.
Morning.
Detective Mowry, could you please state your name and spell your last for the record?
My name is Lawrence Mowry, Mowry.
What's your current job?
I am a forensic detective with the Moscow Police Department.
And could you tell us about your background in law enforcement?
I have 14 years of law enforcement experience in the state of Idaho. I've been with the Moscow Police Department for the last 6 years in this current role.
What is your role in this case?
I was, put in charge of, lead, I don't know. I was the one that was looking at and funneling the excessive amount of digital data and evidence that was coming through.
Have you taken on any other roles in this case? Have you had other duties?
If you're asking about serving warrants for digital evidence, then I've done that, yes.
And you've heard Judge Mike.
Yeah, you're fine. Go ahead.
Okay. Do you agree that the Exhibit A that's been discussed was and attached to warrants, that was a group effort?
Yes,
Have you been a part of that group?
I was.
What role did you have in the first AT&T warrant?
I don't recall specifically. I was there when it was being discussed.
Do you recall that you served that warrant?
I do.
When you served that warrant, did you serve it with the search warrant, with the affidavit in support of search warrant attached?
No, ma'am.
Is it your practice to ever serve an affidavit in support of search warrant with the warrant?
No, ma'am.
Were you co-located with Special Agent Nicholas Balance as well?
Yes, ma'am.
What was the distance that you had in proximity to him?
He sat in the same lab that I did.
And so was that a cubicle setting? Can you describe the setting?
It's a secured forensic lab. It has a door.
And then inside, is it open? Were you in separate offices?
It's a single room.
Single room. And so you were literally in the same room with Agent Balance?
Yes, ma'am.
And was that for the entire time that he was co-located there?
Yes, ma'am.
Were you aware of his ability to have access to AT&T records without a warrant?
No, ma'am.
All right, I want to talk now about the cell phone, also known as the USB. Do you recognize that? I should say, I'm so sorry, because there are so many cell phones. Brian Kohberger's cell phone. I want to talk to you
The
about.
physical cell phone or the data from the cell phone?
We're going to talk about both of those.
Okay.
So for purposes of today's argument, we've called it cell phone / USB. How did the state come into possession of Brian's phone?
It was obtained via the warrant in Pennsylvania.
Was a copy of that phone made prior to the search warrant being signed?
Which search
Copy
warrant?
of Brian's cell phone.
Again, I'm asking which search warrant you're talking about, the one from Pennsylvania or the one that we requested once the data returned?
I'm talking about when it was first seized, so it'd be the first,
The Pennsylvania one?
right?
I do not know.
You're aware that a copy of the phone was made and put on a USB,
Yes,
and then a warrant was obtained to search the USB.
yes, ma'am.
And that's the second warrant.
Yes, ma'am.
Was the cell phone searched prior to the warrant for the USB?
The extraction was created before the warrant in Idaho was requested.
Was the extraction searched before the warrant was obtained in Idaho?
No.
And how do you know that?
I was the one that received the extraction.
The extraction, where was the extraction made?
Pennsylvania.
And who made that extraction?
I believe it was Special Agent Tanzola.
And how did Special Agent Tanzola get that extraction to you?
You'd have to ask him. I believe it was using a Cellbrite product.
So what about is the USB not a physical box of the extraction, or is it all digital?
USB is just a storage device that the data would be placed onto.
So with the extraction and the USB, can you explain the process of the extraction being made and it getting to you and it getting put on a USB?
Normally, in a forensic environment, the device is extracted, that extraction can then therefore be placed onto a different storage device for evidence storage or for sharing with other forensic investigators.
And so you said normally, but I'm asking you specifically to Brian Kohberger's cell phone.
The data was placed on a storage device by S.A. Tanzola and provided to me.
Okay, and how did you get the storage device?
I believe it was brought back. I don't recall how I was given to it. It was still in the FBI packaging.
Do you have any personal knowledge of whether or not Special Agent Tanzola reviewed the data of the extraction before the search warrant in Idaho was obtained?
I don't recall.
Okay. Judge, this is one you don't have yet either. This is Defendant's Exhibit A to cell phone. And it does have a sticker on it.
Do you have an extra copy of that?
Pardon?
Do you have an extra copy of that?
No, I handed two, right?
Yeah, and going forward, I need 2 copies.
I will. I heard that message yesterday, Judge, and I apologize. Moving forward, I will make sure that there is that extra. I'm assuming you went up for your clerk. So.
My staff attorney,
Yeah,
yes.
yeah. Yeah. Oh, wait, that's not the right lighter.
And just for the record, as I've been doing, this has been marked Defendant's Exhibit Number A with a date on the sticker of 11/14/24. The document on which the sticker is placed, first page is affidavit for search warrant. Directed to the Moscow Police Department Forensic Lab.
Detective, how did you create the affidavit in support of the cell phone of the USB warrant?
How did I create it?
Yes.
Guess I'm not understanding, that's a vague question.
How did you go about drafting this? Is this a document that you had, that you filled in from, or did you start from scratch? How did you
I don't remember the exact way that I did it, but this isn't very different from, say, an ICAC warrant that I would have had previous intentions to search the cyber tip information that would be already placed into evidence at the Digital Forensic Lab.
So there's knowledge about what you're asking for and lists of things to get, what are you basing that knowledge on?
I would be basing this on information that I've done in previous cases, other warrants that I have served, and other warrants that I have viewed from other investigators throughout my time.
Can you turn to page 24? You see that page?
Yes, ma'am.
And is that page entitled Search Warrant?
Yes, ma'am.
Looking at the first paragraph of that search warrant, is there any reference to search warrant affidavit in the warrant?
No, ma'am.
And is the date of the crime on the search warrant?
No, ma'am.
On page 25, can you turn there? There's a directive to search the premises. Do you see that?
Yes, ma'am.
What's the premises listed as?
155 South View in Moscow, Idaho, in the Forensic Lab. 155 South View, one word.
Does it say USB in that descriptor?
No, ma'am.
Can you turn to page 28? Who is Key Computer Forensic Lab?
Key is not a person, it's a thing. It unlocked the secure cubicle that the USB was placed into by myself so that it was secured. I had the key, and entrance was obtained by Key in the Computer Forensic Lab.
That makes sense now. I thought it was the name of a company, and I don't know why, but that makes sense. Key computer forensic lab. Who was ultimately in charge of searching the USB drive?
The data was extracted, or not extracted, but reviewed by several different people.
Okay, who are those people?
I don't know all of them. Myself looked at some of the information, but not all.
And you said you don't remember all of them, but who else do you remember?
The information was also given to the FBI. The FBI had that information and they examined it.
And do you know who with the FBI?
No, I do not.
Can you turn to page 27? Can you look at page 6? Or not page 6, I'm sorry. Number 6, line number 6. Do you see that? What does that say?
A copy of the warrant inventory sheet were left with the drive.
And that does not indicate that a copy of the search warrant affidavit was left with the drive. Is that right?
No, ma'am.
Okay, I want to talk now about Amazon. Did you swear to several warrants for Amazon?
I did.
Do you know specifically how many?
I do not recall how many.
How were the warrants served? How did you serve Amazon warrants?
I believe that Special Agent Michael Douglas assisted in service of those.
What training do you have in Amazon accounts and records?
I do not have any training for Amazon specifically.
And I think you answered my next question, but there was a reference in the warrants to a special agent locating an Amazon account. Is that the Special Agent Douglas?
I don't recall who was that, who found that information.
How was an Amazon account located?
I don't know.
In your affidavit, where you've got language that talks about what Amazon holds and how it identifies and the list of items that can be collected, if you don't have any training in doing an Amazon warrant, how did you know that, to put that?
I was relying on the experts that have worked with or served the warrants to Amazon previously. I believe that information came from Special Agent Michael Douglas.
And in your affidavit, did you indicate that that was based on your knowledge or on someone else's knowledge?
I based it on mine because I spoke to Special Agent Michael Douglas about it, and he was the one that informed me that this was the information that we could request.
And so did he provide you with a kind of a mock-up affidavit to use so that you would know what language to include?
I don't remember if he gave me a mock-up, but obviously he would have helped me with the wording of it.
The wording of the warrants is pretty technical, right? All the list of items that is asked for?
Any electronic service provider usually has their special way of asking for things.
And so since you don't have training in Amazon, you relied on Special Agent Douglas for that?
Yes, ma'am.
Okay, Google is the next one I want to talk to you about. What's your training about Google?
Again, I have no specific training to Google. I've served various email or warrants on Google for other means.
Is your experience with Google isolated to this case?
No.
You've done Google warrants before?
Oh, yes.
How did you get the form that you used for the Google warrant in this case?
The Google form, I probably relied on previous warrants that I've served.
Do you know how many warrants you obtained for Google in this case?
It's 3?
On January 3rd, that January 3rd, 2023, that warrant asked for Brian Christopher, 1994 at Gmail, 2 phone numbers, and an IMEI number. What's an IMEI?
International Mobile Equipment Identifier?
And how did you get that number to put in the January 3rd, 2023 Google warrant?
I do not recall.
Okay. Were you, in preparation for creating these warrants, were you having communications with Google?
Specifically about these warrants?
About being able to get the data via warrants?
I don't recall communicating with them specific to these warrants.
Okay, I'm going to hand you what's Defendant's Exhibit F to the Google Memorandum in Support. You recognize that?
It appears to be an email between myself and a Francis from Google.
So is this how you were communicating with Google, via email?
I was communicating with Google for other, I'm not sure if this is the one for this specific warrant, I guess is where I'm getting at. There was question of what Google could provide. We served Google at one point with a warrant, and they said it was, they couldn't do it because there would be too much data. So they were trying to assist us in, well, basically not spending $100,000 of getting them data.
So to be clear, when I'm talking about the communications generally, I'm talking about your communications with Google about all the warrants. So was there email and telephone communications or just email?
I believe I spoke with their legal representation on the phone. I don't remember if there was other conversations.
Do you understand the difference between a personal account and a not personal account on Google?
I do not.
Well, there's reference to DeSales and DeSales helping from their end. Can you explain that?
I don't recall what that means.
Do you recognize what DeSales is in the course of this case?
It references an email address that was associated with the defendant.
Okay. And that email address associated with the defendant is a college that he attended, right?
Yes.
And so was there communication with DeSales about them not wanting to produce records pursuant to a warrant because it was educational records protected by federal law?
I was part of a little bit of that. Officer Detective Payne knew more about that conversation, but Yes.
And so what I'm trying to understand is what was DeSales doing to help?
I believe DeSales was just waiting for a warrant. I don't recall completely.
And did you serve the Google warrants?
I believe I did.
I believe you said you did?
Yes.
And consistent with what you've said earlier, you did not include an affidavit in support of search warrant with
No,
that?
ma'am.
Why did you choose the timeframe of January 1st, 2021 to December 30th, 2022?
I don't recall the specific reason why we went back to January 1. It was to include the time that we believed that the defendant had entered Washington, to become a student nearby the crime scene and just prior to that.
But you know that he didn't come to Pullman, Washington until June of 2022, right?
Correct.
Did you review the Google warrant return emails?
Yes.
Did you review, so you said you reviewed them. Are you the one who's in charge of evaluating those materials for this case, or is that designated to somebody else?
The materials came to myself, at which time it was disseminated to other investigators and the FBI as well.
Is it fair to say that between warrant 1 and warrant 3, it's gone from 2 gigs to over 13 gigs of material?
It was substantial information.
And have you done anything to verify whether or not the materials produced are within the scope of the warrants?
I usually made sure that they were from that specific account when it's received, but I did not go into depth of the evaluation.
Let's talk, the final area is about the Apple warrant. What was your role in those warrants? In that warrant, sorry, not plural, singular.
I don't remember that specific one. I know I was involved in a lot of the Apple iCloud warrants.
What kind of communications did you have with Apple to facilitate getting the warrant?
I don't recall prior to.
I'll hand you what's been marked as Defense Exhibit C to the Apple warrant. It does have a sticker on it. And it's not to the Apple warrant, it's to the memorandum in support.
Exhibit C attached to their memorandum dated, exhibit sticker dated 11/14/24. Appears to be a printout of some emails.
Have you reviewed those?
Yes, ma'am.
Can you, does that help refresh your recollection regarding what communications were occurring?
It appears that there was communication between Apple and FBI.
Okay. And were you included in that?
I believe I was.
Okay. And did that include chats?
I believe the word chat means to chat, to talk.
Like telephone talk or Zoom talk, or what was the method?
I believe it was telephonic.
So what kind of help were you getting from Apple, and what was the FBI getting from Apple?
I don't recall the conversation. This was more specific to the FBI's current investigation. As I stated in my email there for the stalking investigation, I was merely just privy to their conversation.
Have all of their materials related to that been turned over?
Who's there in that sentence, Counsel?
Pardon?
Who's there in that sentence?
Sorry, FBI.
I do not know. I wasn't, I don't know.
I have no further questions.
A few questions, Your Honor. Can I stay here?
No.
Okay. Let me move. Just a few follow-up questions. When you received the evidence back from these various providers, did you have access to what we refer to as affidavit for search warrant and Exhibit A?
Yes.
Okay. And did you use that to determine the scope of what you would be searching for from those providers?
If I was to be doing the investigation, yes, I would have looked at those items.
And you testified that several investigators helped MPD in review of evidence back from providers.
Yes.
To your knowledge, did those investigators have access to the affidavit and the Exhibit A?
Yes.
I don't have anything further. Thank you.
Any redirect?
No, Your Honor.
Thank you.
Thank you, Your Honor.
I have no further witnesses.
All right, why don't we take a 10-minute recess, and we will then pick up.
All right, you guys, what do you think so far? Pretty disorganized, massive, ridiculous. I don't know what that was all about, really. Like, just not driving, no sense of urgency here. And so now it's a nice sunny day out here. As you can see, the sky's kind of blown out, but I got the door open over there, my patio, and it's nice. So just enjoy the rest of this hearing. I'm trying to make sure if you guys want, I can crank the audio up a little bit more. I just don't want it to be distorted for us. But God, Mallory was so quiet. You know, I couldn't even hear a single answer he gave. And I thought Tippler was bad. It's like, pull the cotton balls out of your mouth, dude. What the fuck? Anyway, pretty trippy. I don't know how long they're going to be gone. Probably usually like half an hour, right? Then we got lunch is probably... I wonder if they'll make it to lunch. This might take another day. Cool. I'm glad I found a happy medium. And I was saying, Twiz, I was saying earlier that people were having trouble with the audio. I think Swamp Rose or somebody came in and said that other people were having, not trouble with the audio, but with trouble with the stream. So I'm glad whoever is watching made it over here. If this is your first time watching The Purge, please hit that like and subscribe button for me and do all the YouTube things. And we'd love to have you in the chat. Don't be afraid of the name. Meanie doesn't bite. And Tony's here. He's been holding up the camera, and then halfway through the hearing, the camera fell off his head, and they both went tumbling down, and I lost my shit. It doesn't work without the hat, though. That seems to be the problem. But okay, let's try it backwards this time. I don't know. Oh, that seems to work. Yeah, I'll take it. There we go. So coffee's on. I'm gonna go stir my soup in here in a minute. Yeah, I wonder. I love KFC. Who doesn't like KFC? There's a little bit of a cool breeze, kind of whatever blowing in, but it's warm out there, man. I wish you could see me and the outside at the same time. I don't know why it won't. I need to get a polarizer on the lens or something. But yeah, I don't remember the last time I had KFC. You know what I miss though is Boston Market. And they closed the one here. Yeah, I'm just the pretty face, Shaggy, you know. I'm waiting for Jen to wake up. Jen's having stuff, so it might be a couple days before we see Jen again, unfortunately. So put prayers out for love for our Jen, please. Hopefully she's doing okay. She's okay. She's all right. She'll make it through this. But Kenny Rogers roasters. Yeah. We've been getting all the Seinfeld references to the last couple days, Shaggy. The best is when Kramer pictured Jerry as a roaster. I never had Kenny Rogers roasters. Be honest with you. Yeah, I don't even want to. I'm not even trying to. I'm literally hunting, pecking, typing on the keyboard because I'm afraid I'll exit out of the live and we'll lose the feed and I'll be like, oh gosh, you know me, I'm dumb. Joey, you're killing me with this. Usually I'm the bad one here, making everybody hungry. I do have the corn clam chowder or chicken chowder going right now, so that's gonna be breakfast. And I got 2 pieces of that Publix white bread. You're in Florida too, huh, Joey? Are you in northern Florida, southern Florida? Where you at? Yeah, I just been chilling here. I don't know why. Why doesn't Ann Taylor just handle everything? What the hell? Why did she give that to Mass? I don't know. Oh, excuse me while I go to page 75 and then ask you a stupid question. What's an IED? IDMI or whatever. You know, I mean, dude. Oh, wait, who was in... Who am I thinking? I'm sorry, Joey. I knew that. Was it Dan? I don't know. Somebody else's Publix. Oh, that mountain bread. I had that one time, Swiftfly. That honestly makes your sandwiches taste like a pro made them. That mountain bread is insane. It's got all the seeds on it, and it's just the whatever flour they use on it. Why can't you get rum, Twiz? I'll send you some. I'll send you a bottle. My family used to make rum in Aruba. That was what they made. We made Alloway and we made rum. When my grandfather was still alive, they had Alloway was the aloe burn bomb. It was called. And then they had Palmera, which was and still is the local rum for Aruba, and all the cruise ships started buying it. But my family owned they had called it the Kanuku, the desert in Aruba, and so my grandfather bought a lot of land back in like the 20s. And so they used to grow the aloe plants, to make the burn bomb, because the burn bomb was literally just the little specules, the microscope. They're like not microscopic, the little specks that are in the aloe plant, because the aloe plant's like 99% water, but the medicinal stuff is in that little thing, and they turned it into a powder and made this cream that was bomb. I wish I had some right now. They closed that plant, and but anyway, the aloe plants that they used to make the cream were 25 feet tall and 30 feet across. You wouldn't believe how big a aloe plant gets. It's insane. And now they put it in food and in shampoo and sanitize. Had we had a problem back in the day I remember late 70s. We tried to get the aloe. It was called aloe. So you say it in Papiamento, and that's the Reuben language. And copper tone. We got it onto the shelves of the Holiday Inn Surfside, which is on Clearwater Beach. It's like the first hotel, big hotel, nice hotel on the beach. And we got it into the gift shop of that, and people would love it because you get a sunburn and you put that aloe burn balm on, and it's gone in 2 days. Gone, no peeling, nothing. And we got it on the shelves, and copper tone at that time was already huge, and so they kicked us off. They bought the shelf space when they heard that we were competing with them, and so that was a big blow to that company, unfortunately. Am I muted? What's going on? Let me see. How's everybody doing today? Like 17 degrees, that sucks. I do have an extra room for rent right here, so if you want, come on in. Come on down to sunny Florida. Bill Thompson looked like he was just falling apart. I don't know. I'll sit through 20 of these breaks. Honestly, I know everybody's impatient and dying to get back to this hearing, but I'll take 20 breaks over one suppressed hearing. Yeah. BK he does sit still. And look at me, I can't even sit still in my own life. Bouncing back and forth, and he's quiet. But you can just see. He's just waiting to stand up and get out of there and walk home. Be like, this is over, finally. I didn't do shit. And they have no proof of anything. And when I see Meredith dragging her feet like that with these redundant, stupid, non-suppression questions, it makes the top of my head blow up. And then I'm watching Ann, and I saw Ann kind of scolding. Wasn't scolding her, because you don't want to put future pressure on somebody when they fucked up. Well, let's be honest. She fucked up. Anytime you address Payne or Mowry, you ought to be twiz slapping them douchebags up. Oh, so are you trained in Google? No. That's the kind of response I was looking for. Okay. I hope so. I hope they're building up that ammo box, because I didn't see shit. It was just maybe it is, and I forget about the bigger game where they're putting the pawns into place and the battle's about to start. So that's you're right, Twiz. Thank you. You're a good friend. And now you've been flashy thinged. So if you're new to the Purge and you're just watching, welcome in. Thanks for being here. Feel free to jump on the chat. Nobody's meanie, and she doesn't bite. I'm Kane B. I'm your host today. I'm glad you're with us. I don't know why. Apparently, I'm the only one that can figure out how to put gain on the audio to make it actually hearable. I don't know. The first minute of yesterday's hearing, I was like, "This has got to go." So I just threw a compressor or whatever on it, and it seems to be coming out good. Everybody's happy with the feed so far, I hope. And it's been brah, and we're looking for the big like yesterday. That's why I totally missed you yesterday, because it was like, oh my God, where's Twiz? Twiz and I have been like with this for literally the whole time. Every day. Is it every day? I don't even remember a day that I didn't see Twiz and talked with whatever. Night after night after night after night. Here we are. Allegedly 5-6 months from the trial. But in the hearings, right? It's just surreal to me right now. So I want we're both very perfectionist demanding from these attorneys. And she's coming with, oh, pardon me, judge, excuse me, judge, and wrestling for, and it's somebody, I think Meanie said she should have this all tabbed out, ready to go. She looked more like Jennings yesterday. Jennings got put the extra hair gel in today. Did you see? Thank you, Chickbait. You're the sweetest. Chickbait also is another person that was there for me on my bike ride lives. There would be nobody else. I go on an 1.5-hour bike ride, and it's just me and Chickbait chasing bats. And now I guess they're all gathered under Hitler's robe. I wonder what size robe, because he's like 6'6" or something. He's a big dude. So I wonder what size robe. I didn't want to think about what's under there. Sorry, did I ruin anybody's breakfast? I got to go stir. I was trying to hope the court would come back. I'll turn my mic off in a second, but just in case, I'm going to go stir my soup real quick. That when you break up the chicken, it's just sitting on top until it gets real hot. Yeah, that's weird. Yeah, because yesterday I think we streamed like 16 hours yesterday. And I woke up like right before the hearing started, and I'm like, oh, here we go again. Doing it again, baby. We got this. It is a long time in the freaking making. I did put bacon in the soup too, which I can already smell that cooking. Now I can't find. I refuse to use an actual utensil. I have plastic utensils, and I'm gonna stick to them. I can't find them. You know where they are? Oh, that's a fork. I can make some soup. I have sweet potatoes too. Gosh, I should put the sweet potatoes in the soup, but I'm gonna make those separate. Sweet potatoes, I don't even put anything on the sweet. That's how I roll. I'm wild. I just put them in the water in a soup cup. Damn, I know where it is. It's right here. I have a spoon from yesterday. I don't care. It's just my germs. What do you call it? Peanut butter is the other secret ingredient to the corn chowder, chicken corn chowder. Oh, that is a stocky soup. We used to have a place here in Tampa Bay, and I don't know if anybody has ever visited Tampa Bay or back in the day or whatever, but we had a place called the Old World Cheese Shop, and they had this beer cheese soup. They were famous for beer cheese soup. Somebody must have embezzled that company, because all of a sudden, across the nation, does anybody remember Old World Cheese Company? And it was like, what do you have now? Cheesecake Factory. It was like that level. But, I don't think they'd had worked out all the kinks and all the nefarious stuff that goes on in franchising at that point. I want to say by the early 80s, the Cheesecake Factory was gone. And now it's a Marshall's. No, it's a TJ Maxx. It's been TJ Maxx forever. I even worked there when I was in high school. I would like to do a cooking show, because everybody loves food here. And obviously I did too. Because my belly just blocked the camera. Blocked the sun out. That would be fun. I overshell a Titanic documentary, and I keep meaning to do it. I can tell you guys while we wait a couple of really interesting facts about the Titanic. When I first started doing flipping houses, the guy I worked with was the son of my mom's best friend, and we enclosed my porch, and he showed me everything along the way, how to do everything, how to frame, how to make subfloors, and to do drywall and insulation and French drains and the whole thing. Stucco. The only thing I don't do is roofs. I don't do roofs. Although I could. Technically. It's just the same as framing, except for you use the trellis. And with the roofs, I don't do them. I'm afraid of heights, to be honest with you. Even though I spent 2 years on an 18-foot or 18-foot ladder, 18-foot, by myself at 2 or 3 in the morning, hanging, drilling with a powered drill over my head, and I didn't even know to use the hex screws at that time, so I was using Phillips head. I spent $10,000 on glues and screws building that studio. So hopefully I don't know. I think the landlord probably just gutted that place when I left, but it was pretty nice. I have some pictures of it. They're on my Google Drive. Maybe I'll show that later in the show on the next break. I'll get it ready for that. I wish I had. You know what I need to do? I need to set up a adjacent computer, and man, Twiz, I wish you'd visit and just hook up my network. I can't even get my phone half the time to talk to my computer. So I just use email or Google Drive to share files. It's like, dude, it should be so easy. But I don't know. I think with these routers that you get from Spectrum, they're not built to network, so. And I took Microsoft System Engineer classes. I didn't finish the program. Can be so much money to be made down there with people needing repairs. Yeah. Rochelle, if I could tell you where I could start. Yeah. Oh, yeah. Don't, please, nope. Don't get me started right now. I'll start bawling my eyes out. I would love to open a restaurant. I'd like to be, because I like the atmosphere of a restaurant. When you work at a restaurant, you're part of a family. If it's a good restaurant, it's run strictly and it's run like a family. And then, of course, everybody hates you, but you're dad, so you're in charge of the family. But I would like to have something where people believe in the food, and they believe in because a restaurant's more than just a place to eat. It is an atmosphere. It is it's a memory. You're creating memories there. So you should have entertainment at a restaurant. Anybody, even if it's a little kid, singing somewhere, or a nice background music type of thing, or you don't go out to eat necessarily to have big screens with the family. You want to create a treasured dating experience where kids are happy. And then in the back, you got the waitresses and waiters talking shit about the customers, and the customers complaining about everything. And it keeps you there. Okay, we're back.
All right, we are back on the record in State v. Kohberger. Defendant is present. Counsel are all present. I'm heard that there are no more witnesses to present by either party. Is that accurate?
Yes.
Yes, Your Honor.
All right, we'll move to argument then. The defense may proceed.
Judge, I'm going to cover several of the warrants, and then Mr. Logson's going to cover 4. So I'll just wrap all of my argument up instead of getting up and down for each one. My oral argument is not meant to rehash every point briefed or every argument briefed. I'm giving you big picture comments based on the testimony, but I want to make it clear that we're not waiving any written arguments. While I question Corporal Payne and Detective Mowry about some exhibits, but not all, it was not an indication that others are not important. I wanted to make important points, but not belabor. With IGG and Franks having been addressed yesterday and the fact that the primary issues that I'm addressing have to do with general warrants, I'm not going to rehash those arguments, and I'm going to focus on the legal issues, beginning with the AT&T Warrant 1, Pen, Trap, and Trace, also known as AT&T 2, and the cell phone / USB drive. The Fourth Amendment requires particularity sufficient to prevent the exercise of discretion by an executing officer. The particularity requirement's objective is that necessary searches should be as limited as possible. A search warrant must be particular enough so that, as to what is taken, nothing is left to the discretion of the officer executing the warrant. The government cannot seize the haystack to look for a needle, and there is an undisputed privacy interest in cell phone data, including cellular site data pursuant to Carpenter. All three of these warrants were issued in December 23rd and early January 2023. The two AT&T warrants were issued on December 23rd, 2022, within an hour of each other. The first did have a temporal narrowing. AT&T 1 had November 12th, 12 a.m. to November 14th, 12 a.m. The warrant itself was extremely broad and did not incorporate the affidavit. In support of this actual failure to incorporate, the officers admitted that they did not incorporate in the search, but to the extent that the state is going to argue that when the warrant says upon offer and proof, that is the same as hereby incorporates an affidavit, I pointed out the language in certain search warrant affidavits to show you that they do know what it means to actually use the language herein is incorporated Exhibit A, and that same language is not used in a single search warrant affidavit. So the incorporation that would be a remedy for this issue potentially of particularity doesn't exist when the search warrant affidavit is not included. Even if, for some reason, you were to determine that there was English language meaning upon proof, and oath is the same as hereby incorporated, the language in the search warrant affidavits themselves is extremely broad. The affidavit of return signed by Detective Payne, this is on AT&T 1, says that the warrant was served by email, and as he indicated, it did not include the search warrant in support. The description of the property in Exhibit A to AT&T described the property as just a phone number with no other description of the property, which indicates a lack of knowledge of what was actually seized and going to be searched. The second AT&T warrant and install pin trace was requested within 1 hour of the first warrant return at 3:50. The data from warrant 1 was analyzed such that by Special Agent Balance, such that Detective Payne was relying on Balance in his affidavit to support it by saying that the data that had been in their hands for less than an hour supported that the phone was possibly off going south on Pullman at 2:42 a.m. And there is just got to be a question for everybody of how does this massive amount of data get analyzed in an hour to create a second, broader warrant. The warrant language in AT&T2 pin trap trace is extremely broad, and the time frame goes from June 23rd, 2022 to present. The crime of homicide was stated, but the date of the crime was not stated. There was no other specificity in the actual warrant. The warrant asked for extensive data, location data, timing reports, cell tower information, and installation of a pin, trap, and trace, among other many things. And when the warrant was served, a check the box form was included as a cover sheet to AT&T. Turning to the cell phone is first seized when Brian is arrested. It's copied by Special Agent Tanzola without a warrant, and then that USB drive makes its way to Idaho in an unclear fashion. It sounds to me like it came back with Corporal Payne, who was there for the arrest. And when that warrant is obtained for that USB drive, it's put in a safe with just a copy of the warrant that has no date of the crime, and there's nothing particularized about what is to be searched. This creates a general warrant with 100% total discretion and nothing to limit the search. And if you believe that access within a database by somebody unidentified other than Mallory, who's going to evaluate that warrant, that they're going to look and pull that finalized search warrant from the database that everybody supposedly has access to, looking at that search warrant affidavit, there's full discretion to search the USB drive. There's no limitations and no efforts taken to address that. Turning now to Google and Apple. A very instructive case on Google and Apple is the Idaho pilling case, which is 721 FSUP 3D 1113 2024. It's almost totally on point with this case. It is a federal case out of the District of Idaho, but it really couldn't be more instructive in terms of looking at these issues with Google and Apple. There's without a doubt a recognized protected interest of private information in Google and Apple records. Google contained private emails, schoolwork, research among things, and Apple was essentially a copy of a phone and iPad that went all the way back to 2016. 2018 was an indication of when an iPad was purchased, but 2016, according to the documents that were prepared, were when it was identified that an Apple account was first created. Carpenter applies, and to the extent that there may be third-party materials like search history not related or documented, nothing was done to do any sort of segregation with regard to Apple or Google. For the Google warrant, by January 3rd, 2023, law enforcement knew many details that they could have used to narrow those warrants. They knew that Brian hadn't been in Pullman until June of 2022. They knew the names of the deceased, which were not included as language in the Google warrant. They knew the fraternities and sororities. They knew the students' names who had also been at the house on the morning of November 13th, 2022. They knew the date of the crime, of course. They knew emails. They knew social media accounts and names. They knew where students worked. They knew their friends. They knew their phone numbers. None of that was included in the Google warrant to help limit and make that something other than a general warrant. There's no language incorporating these search warrant affidavits, making these broad, sweeping categories, making the productions bigger and bigger. In Google, it went from 2 gigabytes to 13 gigabytes by the third production. And it appears that it's really unclear to these detectives that have taken a huge role in this case, who's evaluating what data and to what extent and what is being produced by it and what is within the scope of what is in an already broad warrant. For Apple, we are missing some sort of legal process that the state just hasn't filled the gap on, and these witnesses don't fill the gap on. We don't know what the legal process is that is referenced between the first request for a preservation in December 21st, all the way until August, when there is a production on a warrant. The steps that have been taken in between to get the information to put into the warrant are completely unclear, and to the extent that these officers who swore to the contents of affidavits now have no memory of what that is, that's invalidating of those warrants. As for the arrest and the car and the apartment, what I will close by saying on those, because it's not an issue of general warrant or a discussion of particularity, those are more reliant on the issues associated with IGG and Franks. And with that, I'd ask that you find that the warrants that I've just discussed are general warrants, not particular warrants, and they should be suppressed.
Do you want to respond to that, or do you want to have the defense argue the additional warrant issues and then address them all?
I'll take your lead, but I'm happy to just to piecemeal this, and I can address just those. I can make this pretty simple for the court. We don't have to go down the rabbit trail that the defendant would like you to go down. The search warrants regarding the particularity requirement. And this group that we're talking about is Apple, AT&T, there was a first and a second, Kohberger's phone, and then Google. All of these warrants were not general warrants. They were all sufficiently particular. They were specific to the type, each one of them listed that they were specific to the type of crime, the location, and all but one of them had temporal limitations. And for the one that didn't, that would be the cell phone warrant. That warrant was more particularized in the types of data that officers were allowed to search for. It's the state's position these were not general warrants, and your court can determine that just by looking at the face of the warrant. If you have any questions, otherwise, state submits, you should deny their motions to suppress for these issues.
Your Honor, I was asked to argue the motion regarding the raid on my client's parents' home, the search of his person here in Idaho, as well as in Pennsylvania, as well as and the Amazon warrant. I think for the most part, I'll just rely on the briefing. I just want to clear up a couple of things. One of the areas that was covered in the Pennsylvania home raid was that the state had to have a valid warrant in order to enter the home. I think in the briefing it gets a little confusing, but the point was not that Mr. Kohberger couldn't have been arrested as he was walking down the street via the usual channels in which that could have occurred. the point was that they had to have a valid warrant in order to get into the home. The only warrant that they have is the one that we're challenging via the Franks motion. And so that was the purpose of that argument. The other issue in terms of choice of law, it sounds like the state's kind of accepting that Idaho Constitution should apply. We set out a few different reasons why that should be the case, but it doesn't seem like there's a big argument going on there. So unless the court has questions about it, I'll leave that alone. And then the other issue that I wanted to touch on is the right of privacy in the information that we have in our Amazon goings about. Why should the state have to have a warrant for that? I thought we set it out pretty well in the briefing, but I think, the big concept and takeaway here is in Carpenter and Riley, the United States Supreme Court starts doing something different. And I think what the court is starting to recognize is that to a great extent, the United States has become a sort of panopticon. That is, the concept of the panopticon is you have a prison in which you only need a small number of guards because you have a very heavy-duty surveillance system. In the United States, we have via our phones, via the internet, much of what we do is now surveilled and very easily accessible. And so the fact that we have the third-party doctrine made sense when it was being adopted back in the 70s and the 60s. It stops making sense once all of this information is easily accessible in the way that it is. And so our point is that the judiciary has to have a role in this. There has to be a judge between us and the executive. Otherwise, we're essentially allowing the executive to know everything about us all the time. And so the state makes the point that, similar to the one that Professor Kerr made about going and getting bank materials, once those were things that could be done simply and efficiently via these records, a person didn't have to go out and get the cash. The state argues in this case, because of Amazon, Mr. Kohberger didn't have to go someplace to purchase items. All of that would have been out in public, but he's doing it on his computer, and so why should that make it private? And the reason why that has to become private, Your Honor, is because of the vast amount of information that is now so easily accessible to the government. If we don't require a warrant, we essentially put all of ourselves at hazard of being snooped on at any time. And so I also just want to briefly bring up, I think yesterday the court had talked about privacy rights with the IgG databases, and I certainly want to make sure that we are preserving that argument. We included it in the briefing. We do believe that Americans have a privacy interest in the genetics that they share with other people and that other people then place within these databases. So that is not something that we intended to abandon in any way yesterday. If the court has no other questions for me, I would rely on the briefing.
Thank you.
Thank you.
Your Honor, I'd like to address just the third-party doctrine, and then I'd like to turn it over to Mr. Thompson to address the other motions to suppress. And the case that we're talking about is the Amazon records, and that's what has to do with the third-party doctrine. And the U.S. Supreme Court case State v. Miller is the controlling case here. And Idaho courts, as explored in my briefing, apply Miller. And there's no reason for this court to diverge from that Fourth Amendment analysis. The documents are Amazon's business records. They detail transaction history. Business records are most akin to bank records, which is allowed. Applying the court's reasoning from Miller, again, these documents are business records of Amazon. They're not the defendant's private papers. Amazon is a party to those transactions. They have a substantial stake in these records, And the defendant took the risk when he revealed his affairs that this information would be conveyed by Amazon to third parties, including the government. It's the state's position, and it should be the position of this court, the defendant does not have a Fourth Amendment privacy interest in Amazon's business records. Thank you, Your Honor.
Good morning, Judge. I'm going to address, I guess, the remaining warrants or the questions raised by the defense about the remaining warrants. I'd like to start first with the warrants for the residents in Pennsylvania. That expands into Mr. Kohberger's person under the Pennsylvania search warrants for his person, for his car, which was in Pennsylvania, and then the defense also raises questions about statements made by Mr. Kohberger to law enforcement. First, as to 119 Lambston itself, one of the first things the defendant offers to the court is claims that there was no local warrant, valid local warrant, and that simply isn't true. As the record clearly demonstrates, there were 3 valid local warrants, Pennsylvania warrants, for the residents, for the defendant's person, and for his car. The defendant then asserts, and I appreciate Mr. Logston's clarifications, but essentially the defendant asserts that there needs to be a separate special warrant in order for Pennsylvania to take the defendant into custody as a fugitive from Idaho on our charges. And as we cited in our briefing on this, the statutes in Pennsylvania and Idaho are virtually the same, and they clearly contemplate that a felony fugitive can be taken into custody without a fugitive warrant under the circumstances that exist in this particular case. Now, if the issue is the law enforcement presence or access to the defendant inside his parents' residence, we would submit that's already addressed because the Pennsylvania State Police had a valid search warrant for the premises, for the defendant's person, and for his car. So they had lawful process to be where they were, where they found the defendant and took him into custody as a fugitive. The knock and announce, there was discussion earlier today on the explanation of what happened with the dynamics of the knock and announce. That's detailed in Sergeant Lang's statement, which now has a current cover affidavit to it filed with the court. That's S5. I'm not going to publicly go through all the factors unless the court wishes me to because they are quite incriminating as far as the applicable factors that would justify either an abbreviated knock and announce or, frankly, elimination of knock and announce entirely. And from what we have before the court now, it's clear that the Pennsylvania police were operating in a dynamic sense, reacting to real-time information that was coming in. That's all documented in the various reports and log sheets that have been submitted with our pleadings, which are not particularly lengthy in nature. Finally, as to the defendant's statements, I think the key notion here on any statements the defendant made, and frankly he really didn't make much in the way of incriminating statements, is there was never any interrogation. He was Mirandized eventually, but even the prior conversations that occurred with Pennsylvania law enforcement, there was never interrogation. And so Miranda is not implicated, and so there's no issue on the statements themselves. As to his car and his person, as I've already mentioned, there were valid specific Pennsylvania search warrants for each of those, so those are presumed to be lawful. There's been no substantive attack on those. There is a motion to suppress regarding, and I'll use the air quotes, arrest warrant, and frankly, I have yet to be able to figure out what arrest warrant is being referred to. But again, all the actions in Pennsylvania were taken pursuant to valid warrants, search warrants from the Pennsylvania courts and the applicable fugitive arrest statutes. And so we don't see that there's any issue before the court there. The defense also raised the issue of a search warrant for the defendant's person in a separate motion, which appears to be the search warrant for the defendant's person here in Idaho when he was returned to Idaho. And as the search warrant and the affidavit for the search warrant show, which were attached to our reply, there was a valid search warrant for that. I think any issues to be argued beyond that relate to the ITG and Franks that are already pending with the court. As far as the defendant's, the search of the defendant's apartment in Washington, for whatever reason, the defendant did not include all the documentation with their particular motion to suppress, but we provided that in our response, that there was the Washington search warrant. There was also an amendment to the Washington search warrant. The Washington search warrants, the applications, included all the information, the Exhibit A information from the state, and then the WSU Police Department added their additional state of Washington specific information. There's nothing to question the validity of that warrant on its face. So, Your Honor, unless the court has questions, I don't have anything further to offer in the way of argument, oral argument.
Thank you.
Thank you, sir.
Fox, any rebuttal?
Your Honor, I think I just rely again on the briefing for the most part. In terms of the knock and announce, I think the totality of the circumstances of this particular raid are something that the court has to be cognizant of. I mean, if Dylan Roof could essentially be picked up in a parking lot outside of a drugstore or whatever it is that they were able to do.
Telling me facts about which I have no idea, and so it's not going to be helpful to compare it to, well, whoever Mr. Roof is, so.
I guess the point is that in this particular case, the state manufactured the exigencies, if they had them at all. The reality is, as they explained in their own affidavit, they're essentially watching Mr. Kohberger as he moves around his house via snipers. I mean, they were quite safe, and there was simply no reason to bash the doors in momentarily after yelling from their Bearcat.
There's two issues. There's officer safety. There's also destruction of evidence concerns.
In the cases that we cited, Judge, when the claim has been that there's evidence being destroyed, the evidence, what's known to the officers is something along the lines of, they hear somebody running away after they announce themselves. It's not typical that the police simply don't knock and announce at all in those cases. They usually give the person the opportunity to surrender, but it's not a particularly long one. And in this case, they don't do that at all. And the only thing they knew is that he's walking around from room to room and that he has some kitchen gloves on. And I don't think that equates necessarily to the destruction of,
Well, that's not all they knew, but I won't go into the detail in order to preserve so as that we don't go into those issues.
Thank you, Judge. But beyond that, we'll rely on the briefing. Thank you.
Okay. I'll take the motions to suppress under advisement and issue ruling forthwith. The next issue is the state's motion to compel regarding the defendant's expert disclosures.
I'm sorry, Your Honor, the defendant's motion to compel the
Did I say the state's motion to compel? The defendant's motion to compel regarding the state's expert's disclosures.
We did file ours yesterday, so their motion may be coming.
Well, I would be impressed if they had filed something already on that, given they were just served yesterday afternoon, so.
They were. Thank you. Your Honor, we are here on our motion to compel, asking that the court remedy what the state has done with their expert disclosures. We rely on Idaho Criminal Rule 16 and the court's order setting out what we should do and when we should do it in this case.
Let me ask a question from a framework standpoint. I don't know what these folks are going to testify to at trial, specifically as it relates to what they've disclosed. The way expert disclosure issues usually works, I don't tell a party what you have to specifically disclose about your experts. You disclose about what you think you need to disclose. If you haven't disclosed it consistent with the rule and you try to offer it, there's a good chance it may not come into evidence. That's the general framework, so I'm a little, I guess, concerned about what appears to be you asking me to tell them what to say in their disclosures.
The court brings up a really, really good point, and I think it's a remedy the court has and one that we would hope and ask the court to issue in this case. I think when we filed the motion, Your Honor, we had a couple of disclosures that could appear to be disclosures with wiggle words in them.
Yeah, wiggle words are not going to save the lack of disclosure. I'll let the state know that right now. The fact that you say, well, he could talk about anything else, doesn't mean he's going to get to talk about anything else.
In an abundance of caution, we were worried about those words. I appreciate what the court's saying, and I'm going to make this really short. The lists are problematic for us. There are 4 or 5 experts with lists. I understand what the court said. I like what the court said.
They also have reports that they reference.
The lab people do have reports. I understand those are their opinions. When we're talking about, and I'm going to specifically talk to you about their disclosure number 7, it's an FBI agent, Douglas. There's a list of financial records that he collected and looked at. Other than that those records exist, there's not a report telling me what they mean to him at all. If he's limited to say, I collected these records, this is what we have.
My understanding, the state can correct me, is what I understand from the briefing is respect to that, and I think that's the Amazon documents, correct?
Those were some of those documents, Your Honor. There are a lot of others.
Was his expertise was in extracting or reviewing the information and how those were sort of obtained electronically and then simply guiding through, well, this is a transaction on this date that does this, which is not necessarily expert testimony, it's simply testimony.
No, but I believe it's a different expert that they have to do that does not have a report.
But is that expert testimony? That, let's just say, Mr. Kohberger on X date purchased a television, if for some reason that were to be important, and that this transaction demonstrates that this is Mr. Kohberger's account, this is Mr. Kohberger's credit card, and this is the purchase on Amazon. And that was delivered to this address associated with Mr. Kohberger.
Those are factual issues, Your Honor. It's when we get to what do they mean, or I put these things together and I've made this picture out of something. That when we get to opinion, I appreciate what the court's saying. It sounds to me like lists don't do it if you want to interpret a record. That's what we hope to hear. That's what I wanted to accomplish today.
Well, I think it's pretty clear. You cannot simply say an expert's going to talk about topic A, topic B, topic C, and then be able to give a host of opinions that fall within those topics. The requirement is to list what their opinions are and what they relied on to give those opinions. It's different than the civil rule. I don't think they have to give as much detail as the civil rule requires, but they have to at least give what the opinions are and I believe what they reviewed, as I recall the rule off the top of my head.
I believe the court's about right. There may be another term or two in the rule that's specific, but I hear the court loud and clear. I'll point out one last thing and stop because I think I understand how the court interprets these issues and these rules. When you look at page 9 of the state's objection to our motion, and in the second to last paragraph, they tell you that they will continue to supplement their expert responses based on later discovery or whatever they decide to use. That whatever they decide to use has me worried. So I wanted to bring that up. I appreciate the court saying the court's going to apply the court rules and the discovery rules and follow the case law, and that's all we want. Thank you.
And so that I'm clear, as the state's approaching to talk about this, in terms of supplementation, it's allowed. It needs to be seasonable, which means it has to be not just whole cloth new experts, for example, without good cause showing me why that's necessary. It needs to be seasonable in the sense of the timing of it based upon when the information was received, when it was determined it was necessary to supplement. And then obviously we'll look at that in relation to what may prejudice the other side in terms of the timing of it.
Certainly. I understand that. Their discovery deadline has come and gone. If something brand new happens, that would be a different issue. I would assume we would deal with that then. It's when I read whatever we decide to use, that's very, very broad. That's it. Thank you.
I can keep this pretty short. I don't think that there's really much in dispute at this point. State's position, we've complied through our expert disclosures with Criminal Rule 16b-7, as well as your court's scheduling order. State understands the framework that you've outlined. We were under the same impression, and I don't think that there's anything else in dispute.
Yeah, so let me give you a word of caution. Sometimes there's dissonance between what an expert thinks that they're going to talk about and what the lawyer understands from that expert. And the lawyer submits these disclosures. And I think it's really important that you be on the same page if you don't have a specific written report from the expert about what it is they're going to talk about, and make sure that you have supplemented and that you have provided a listing of the opinions that are going to be provided and whatever else is required under the rule in terms of what that's based on. And I would encourage both sides to over-disclose those opinions in caution rather than under-disclose. Because two things. One, you may find yourself in a bad position if you're not allowed to go into an opinion you felt you were going to be allowed to go to because it's not disclosed. And two, I don't want to spend half our day at trial with me saying, where's that disclosed at? And then chasing the jury out while you dig through your thousands of pages trying to find where that is. And so the more exhaustive your disclosures, the less likely it is it's going to draw that objection, and the less time that we're going to waste at trial trying to find where you disclose that. And so I think sometimes, and I'm not saying you did that in this case, I think sometimes lawyers view this expert disclosure requirement as sort of tedious work that they need to get done in order to comply with the timeline, a requirement of the court, and then they sort of move on from it and forget about it. That's a dangerous tact to take. It is, for the case, one of the most important things that you can do is to understand what the person is going to testify to and give a disclosure of what they're going to testify to, what those opinions are. And to be looking at that as you're thinking about their testimony, as you should be doing certainly now, even though it's months away from trial, on a continuing basis. So I would really stress the importance of that in a case, particularly of this import. And so don't feel like your job is done at this point, because I would suggest to you it's not. That you may consider needing to do some cleaning up and making sure things are more fulsome in the scope of those disclosures and what you're doing. The other thing, I think you tried to do to a degree is you thought, well, we think this is fact testimony, but, in an abundance of caution, we're going to put it in an expert disclosure. Well, if you're going to put it in an expert disclosure because in an abundance of caution it could be viewed that way, I suggest you treat it that way in terms of what you give. Okay? Thank you. And that goes to both sides. I haven't read your disclosures yet, so I don't know, where that stands, but certainly goes to both sides. And I know that also, the rules are different as to what the defense has to disclose necessarily and what the state does to some degree, and so I appreciate that.
Well, I think the court will anticipate that there's a rather large filing that contain a lot of actual reports. Your Honor, listening to the court's comments and understanding where we were a moment ago when we spoke, I feel like I must go through what their disclosures were because there are so many lists. My hope was that they would be limited because they didn't fulfill their disclosure requirement, and we did, and that put us at quite a disadvantage, not knowing what their experts would say.
And if they supplement, you certainly can supplement based upon what they supplemented, and I will permit that, and that's kind of the nature of the beast.
I do appreciate that, and should that become necessary, we'll definitely take you up on that, Your Honor. I want to make a record about some of their expert disclosures, though.
Okay.
All of the lab people, they have lab reports and notes. The Idaho State Police Forensics Lab, I better be really clear on that. Other than the wiggle room language, which would ask that they not be permitted to have any wiggle room language, the lab reports are fine, with the exception of one of the witnesses, Ms. Nowlin, that they've disclosed, and she's written no reports.
Is that the one they said is a rebuttal witness?
They said she might be a rebuttal witness, so I suppose now they know what our witness is going to say. I want to talk about the CAST report. The court's heard a lot about the CAST report. When I say CAST report, that's because that's what it's called. It's really a PowerPoint presentation. There's not any analysis in that. There's just, this will be my testimony. This is what it's going to be. Without much more, it's a picture, and it has some dots and some arrows. Your Honor, that needs to be cleaned up. We need to understand the analysis that went into coming up with those PowerPoint presentations. That's just not plain good enough. I would let the court know that the cell phone experts, there's wiggle language in both of those if the court hasn't seen that. Their disclosure number, that's Mr. Cox, that's a person that has not written a report at all. We have no idea besides the state's disclosure what that person's going to talk about. Agent Douglas that I talked about before, I don't think I need to make further record. There's a lot of documents, no analysis, no opinion stated. We put several of these in our pleadings, and so I won't go through all of them. I'm highlighting the ones that we're really concerned about. We have 3 that looked at digital data. The court should understand there's 60-some devices. There's digital data from third-party sources, and there are 3 people that are listed with just lists of things. It's Mowry, Tanzola, and Uric. They have lists of devices or social media accounts that they're going to talk about. That our expert told us would take 3 years to look at every bit of the data. So having no clue what's going to happen, I can envision exactly what the court's fear is when we get to jury trial, me wondering if this particular thing was ever disclosed. So I definitely needed to make a record of that. Further, with the lab personnel, there's a caveat that says they'll talk about other people's reports and other things that are outside of their report, in addition to some of the other wiggle language that I referred to. Your Honor, given that the state is now cautioned to think about those things and submit more, I feel like it's important for us to bring out that we have a right to confront the evidence that's brought against us. Brian has constitutional rights, United States and state of Idaho constitutional rights for a fair trial and to confront evidence. The expert disclosures are designed to advise us of what the state is going to do. Their disclosures were insufficient. I appreciate what the court said, But exactly what the court's worried about will happen if we don't have better disclosures. The jury will be in and out while we make sure that we have a clean record. We appreciate what the court said today, and we'd ask the court to order the state to comply or for the court to exclude anything that hasn't been disclosed so far. That's it.
So I'm going to give like both sides an example of what I expect so that you understand. There's been talk in this case about DNA. If somebody's going to talk about DNA and your intent is they're going to let the jury understand what DNA is and essentially going to do a mini course on DNA, I expect to see that in the expert disclosures. Not that they're going to do a mini course on the DNA. I expect to see the mini course in the disclosures, if that makes sense, in terms of what their opinions are, what their information is that they are conveying that is expert in nature. And so it really does behoove both sides to spend the time to do that. And that's the last I'll say about that. It is probably the most critical thing that you have to do at this point prior to trial is to ensure that you have not just disclosed, but potentially over-disclosed those opinions and what is required by the rule. All right, is there anything else with respect to those?
Your Honor, is the court giving the state a new date to fix their disclosures?
I'm not giving either side a new date. You understand, I think, what I expect. So you can choose to try to supplement those. If they are simply expansions of what it is that they've disclosed that are just being more fulsome, I'm probably not going to have a problem with that given where we're at in advance of trial, and the defense certainly can look at those and decide that they want to expand or change or whatever their opinions are based on that. If it's whole new stuff, then you're going to have to demonstrate to me, new opinions, new lines, or even new experts. You're going to have to demonstrate why you didn't get that in the timeline.
Thank you.
Okay, is there anything else that we need to take up today?
Nothing from the defense.
I don't know whether we're going to have a Frank's hearing or not. I need to go and do that. But if you don't mind emailing some dates that you have available in the next, say, 3 weeks to do that in the event that we need to do it, I would appreciate that. Okay? All right, well, I appreciate everybody's work, not just for the hearings this week, but in this case in general. And I know how busy you all are, and I hopefully have not taken more of your time than is necessary. Travel safe. Thank you.
All rise, please.
Sorry guys, I was eating my soup. Wow. What do you guys make of that one? He said, I don't know if we're gonna. He sounded pretty sure that it wasn't gonna be a Frank's, in my opinion, I don't know. It sounds like we're getting ready for trial, guys. I that's all I can say. Uh-oh. What happened?
Kroger Boost just got better. Now you can choose from Disney Plus, Hulu, or ESPN Plus on us, along with great benefits from Boost, like 2.
Looks like it's over, guys. I guess that was it. Sorry about that, guys. But, alright. Well, that's today's broadcast. Everybody get some stuff done. Get some soup on the griddle there, and stay warm. I appreciate you being here. It was short and not sweet today. I can only imagine that he's going to go in and make his decision now, and we'll more than likely know in the next couple days. I don't know why if he's already decided, then I don't see why he just didn't say it right there. It's like everything's got to get dragged out. And I understand the legal process is slow, but when you are going out of your way to drag your feet, I don't know. That just seemed like a going through the motions day. For sure. Well, you were quiet, Leslie and Billy. I was wondering if you were still here. I don't think he likes anybody. I'll be honest with you. That guy is... He's got that... That's why you see both sides are honestly very genteel. They're fragile in their approach. So... He's got a dark side. I think that whatever it may be, they know about it, and they know to avoid poking the bear. So, sorry about the clipping there, guys, if I woke up the kids. Yeah, I felt like there should have been some screaming from the rooftops at this point. I mean, she said everything that needed to be said. She said they still haven't given us what we're asking for, and he shut her up again. So there's no repercussions for not abiding by due process, and it's disgusting. We have, I think, probably a worse judge, but maybe a better jury pool, possibly. I don't know. I don't think there is a good jury pool in Idaho. I really don't. And I'll be honest with you. As far as the heartland and the Midwest goes, it's a very narrow mentality there overall, and they point a finger, and no matter what, that is what is that is what that person is instantly forever banished, whether they're guilty or not. And it seems like they're playing into that a whole lot. Jennings, shush. Is that you, Heather? I know it's you. Nice to have you with us today, Jennings. Oh. Yeah. I think he's going to boss the jury around, to be honest with you, Thomas. He is a very overbearing, boundary-breaking fella there. What account? Is that Angel D? Ultimate Idaho inside hipster. We're all about the Seinfeld references today. Man, that is soup. I think as long as it's chilly, I'm going to be eating soup from morning till noon till night. Yeah, I guess other people were saying that there was a problem with streaming I seem to be the only one that, and unfortunately at the end it blew everybody's eardrums out. Sorry about that, but I guess now I can remove that. Filter, it's a gain, it's just called gain. It's basically a limiter, compressor kind of thing. Audio rack mount stuff. I don't know why anybody else hasn't figured out how to add one to their stream and have a, because 90% of video is the audio. Try watching a movie with no sound. You can't do it. Even with the closed captions on, it doesn't make any sense. You got the music, you got the atmosphere, you got the inflection of the voice. And she's talking like this. You can't hear a thing she says. Even Ann Taylor. A little bit more, Judge, but I don't want to offend you. And, you know, Jason was quiet too. I don't see, Rochelle, any reason to go any further into today. Today was kind of a phone it in day. I will be on the streets again, checking out, like Lana and everybody, and then I will do a Saturday Night Live this week, because we're at Thursday, and that's the beginning of my work week, so that'll be, we'll see if I start doing late night lives or... Alright, Shaggy, thanks for stopping in, brother. Have a great shift. And, I'm going to go over there and check out Lana now. But I'll be back up with, hopefully with Jenn, on Saturday night for sure. And, yeah, they I don't know what today was. His decision was already made. Oh, is today Friday, mean? Yeah, so I'll do one tomorrow. Why was I thinking it was Oh, that's right, because the first hearing was on Thursday. Thank you, Mimi. But so tomorrow night I'll do a show, and then I start my work. So we'll see what my schedule. I'm going to try to keep it where it's the 7 o'clock thing. I like doing that. I like, hopefully it can grow there, because the late night thing was doing real well. And I changed it up. I'm trying to get more of a regular people schedule and stuff. I'd play some stuff for you guys, but I didn't pull up a damn thing last night, I don't think. I just went right to bed. I feel like I denied Shaggy his Doubtfire. I think I'm gonna start doing a half Doubtfire, half Rockford song for my intros. I'm open with the Doubtfire, and then do the funny stuff, and then do Rockford song funny stuff. So that's my plan anyway. I wanted to pre-record all that stuff, so it's not like, but I kind of like doing. Thank you, Angel D. Stop getting banned everywhere. We need you around. I appreciate it. So, alright, with that, I'll let you go. Thank you for tuning in. If you're watching, please do all the YouTube things and hit the subscribe button. I'm Kane B. I was your host today, and I will see you on Saturday, my friend.